The Supreme Court recently ended its closely watched 2024 term, where some of its biggest orders came from its shadow docket.
No longer will we have rogue judges striking down President Trump's policies across the entire nation.
In one of its final high-profile decisions, the Supreme Court limited lower courts' use of what is called a universal injunction. The case concerned President Trump's executive order limiting birthright citizenship for babies born to people in the U.S. illegally or temporarily. Federal judges in 3 states ruled Trump's move unconstitutional and blocked the order from being enforced anywhere in the country. Justice Amy Coney Barrett and her conservative colleagues ruled that the judges overstepped their authority. Though the legal battle over birthright citizenship will continue, this ruling gave the Trump administration a major win.
There are a lot of universal injunctions that are going to have to be removed by the courts, which is going to allow many of President Trump's executive orders and other actions to go forward.
That was just one of many cases the High Court considered from its shadow docket. In March, the judges directed the Trump administration to pay $2 billion in foreign aid to nonprofit groups for work they had already completed for the government. And in April, they denied the administration's bid to dismiss the legal case surrounding the deportation of Maryland migrant Kilmar Abrego Garcia. But the court has sided with the White House on other emergency applications. That includes ending a Biden-era program that protected more than 500,000 migrants from deportation and allowing the Trump administration to deport immigrants to third-party countries. On the court's merits docket, religious freedom played a key role. An evenly split bench was unable to rule on what would have been the first Catholic charter school, leaving a lower court block in place. The court did reach majority to side with religious parents in Maryland, who were refused the option to remove their children from public school lessons with LGBT-focused materials. In other closely watched cases, the court upheld Tennessee's law that bans gender transition procedures for minors, as well as a Texas law that requires pornography sites to verify the ages of its users.
States have a legitimate interest, an important government interest in protecting children from obscene images, and that these kinds of age verification requirements really only had an incidental burden on adults' free speech rights.
To share his insights on this Supreme Court term, we are joined now by Eric Kniffin. He is an attorney and fellow at the Ethics and Public Policy Center. Thanks for being with us, Eric. First, let's look at one of the court's decisions on religious freedom. Mahmoud versus Taylor restored the rights of parents in Montgomery County to opt their children out of public school lessons that violate their religious beliefs. Eric, does this case only affect parents in Maryland, or does it have a national impact?
This is a national case, and it's really important. Montgomery County was arguing that parents' rights, the fundamental right of parents to direct their children's education, only comes into play when the school is coercing children. And the Supreme Court says, no, that is not the right standard. And that's really important here.
That is important. And though many have criticized the decision in another case in Trump versus Casa for its potential impact on birthright citizenship, the case had nothing to do with the rights of unborn children, but on the lower court's use of universal injunctions. Eric, why are these injunctions so controversial?
So traditionally, in our American system, courts are there to decide cases and controversies, and that is issues between the litigants. And so that is generally the limit of what the effect of courts' decisions. There has been a trend in recent years to change that, and it's really been accelerating. There were 24 universal injunctions during both the Biden and Obama presidencies over 12 years, whereas President Trump has had 79 issued against his executive actions, and 92% of those by democratically appointed judges. So it's been a real change. The Supreme Court's decision is an effort to try to rein that back in.
Eric, we've also seen Justice Amy Coney Barrett face harsh criticism from some Republicans for what they see as breaking from her conservative colleagues in certain cases. A New York Times story wrote that she is showing signs of a leftward drift. But Eric, it was Barrett herself who authored the opinion in Trump versus Casa. Has she silenced her critics? What has this term revealed about Barrett as a justice?
I think the attacks against Justice Barrett have been unfair. I think, like her mentor, Justice Scalia, she understands her job is to apply her judicial philosophy and decide cases and not produce politically favorable outcomes. So I have not been happy with the criticisms of Justice Barrett. But at the same time, I'm grateful that this decision has helped reassure conservatives that she is an excellent justice, and we're grateful to have her.
And what do you think, looking at this term, what do you think these decisions reveal about the dynamics of the high court right now? Both the conservative and liberal justices have written strongly worded opinions against their colleagues. Is it a sign of strained relationships on the bench, or is this standard of justices?
I wouldn't say that it's strained personal relationships. I think it's hard to say that. We do have justices with very different views of the courts and of the American project and what the roles of judges is and the role of the Constitution. And I think these opinions reflect that. Our justices do have different views themselves. And our judiciary is the most transparent branch of the federal government. It's the only one that's required to spell out in detailed written opinions why they're doing what they're doing. And so I don't think it's a bad thing for us to see that out in paper, to see here are the disagreements, here are the different views, and let those play out.
Looking ahead to the next term now, the justices are hearing a case centered around Colorado's ban on what is commonly called conversion therapy. The Christian counselor who brought on the case says the law prevents her from sharing her clients a biblical approach to gender dysphoria and same-sex attraction. As a point of clarity for our viewers, the Catholic Church does not have an official stance on the practice. But Eric, what could this case mean for religious freedom and free speech?
I think this is a really important free speech case, and it does have religious liberty implications too. We just saw a related case, United States versus Scrimeti, which dealt with Tennessee's law over banning gender transition procedures for minors. And as part of that opinion, there was discussion among the justices about, the science here is not as locked down as the left would presents it. And there's a lot of concerns that get to this core question is, how should we best help as a society children who struggle with their gender identity? That's a legitimate question, and that is not a closed question. And I think that the Supreme Court will hold that there is a free speech right for counselors to pursue something with their clients other than what the dominant ideology and people at WPATH would have us do.
And finally, Eric, just last week, the High Court announced it will examine laws in Idaho and in West Virginia that ban biological males who identify as transgender from competing in women's and girls' sports. The conservative majority has shown it's receptive to laws that protect children from gender ideology. So do you anticipate they will side with these laws as well?
I do. We saw this in Scrimeti. The Supreme Court dealt with a similar issue and came out saying, no, these laws, that law in that case discriminates on the basis of sex and on, not on sex, but on age and on medical procedure. And those are legitimate distinctions. There's some similar issues here. There's competing arguments about what type of discrimination is going on here. Title IX says that as a general matter, schools may not discriminate on the basis of sex, but it has certain carve-outs for bathrooms, for showers, and for sports. And I think the Supreme Court will apply that and will say that it is legitimate for schools to say that women's sports are for women and to decide that based on biology. And I think that's how that case will come out.
Eric Kniffin, thank you so much for sharing your insight with us, and thank you for your time.
You're very welcome. Good to be with you.